Gunworks, but in the Gunworks case, we were in the transition of moving to the old section, and then the construction was underway. That was really a tough slog because we didn't have enough room, and we did get through the trial. It's up on appeal. I have no idea what will happen to it, but it was a very contentious, long case. This case is Gunworks. Gunworks was filed suit against a variety of entities. Those entities have in turn filed suit against other entities, and they filed third-party complaints, which means that the individual defendants have said, we are bringing in other parties in the litigation. We now have 10 different law firms involved in the case, 10 different causes of action. We originally had about 16. We made some rulings on motions for summary judgment and dispositive motions, and as a result, some of those litigants are no longer in the case. However, we've kind of come to a situation where we are going to make a set of final rulings, which will be late this week, but depending on what happens, there will probably still be 7 or 8 individuals in this case. Now, what does that mean? That means you're going to have probably 2 to 3 attorneys on each side, 21 to 25 attorneys in a courtroom. There's no way we can get those tables set up in that courtroom. It's impossible. And I assure you, and I'm willing to walk you all through it if you have any doubts, but I'm in that courtroom every day. I've tried hundreds of lawsuits in my life. And there is no such thing as a good lawsuit when you're right on top of each other, because there's tension between the attorneys. They have different opinions, different sizes. And then you've got the jury, which is right there looking at their notes as they go through it. So what we've tried to do is this. We've reached out to the Holiday Inn because there are locations, and that is really the only location I can think of. People have mentioned things like the auditorium, the rec center. You know, those places are just not feasible for a courtroom. We have gone with Deb Carroll, the clerk, Teresa Rowan, my judicial assistant. We've walked it through. They would be able to accommodate the reasonable equivalent of a very large courtroom. We'll have a bench set up. They'll help us with that. We'll have tables allocated for each of the counsel that'll be adequately separated, so they won't be right on top of each other. We'll have a jury box that'll be very, very similar to a large courtroom. We'll have everything that would constitute a courtroom as complies with Wyoming statute. Now, the question may be, well, but the issue is we just don't have the money in our budget to pay for that room, for the other ancillary services required. And I know the question may be, well, you know, I'm a state employee. I'm overseen by the Wyoming Supreme Court. They're effectively my boss, and I've reached out to the Supreme Court. They don't have the money, but they have said, Simpson, we'll give you an alternative. The largest courtroom, and I've tried cases in this courtroom, is in Green River, Wyoming, in Sweetwater County. Okay, well, if we have to take our crew, Deb's staff, Teresa, et cetera, and Deb can give you those numbers, that's going to cost roughly the equivalent amount of if we were to pay for the Holiday Inn. Now, the situation would be with the Holiday Inn, they've also agreed, this I think is a unique concept. This is March. We all know March in Cody. That is not particularly a busy tourist year, unless you're here for the ice festival, and even that's not scheduled. So I'm not sure why you'd be in Cody, but people do come, but they're only about 2 or 3 at a time sometimes. So we can get a rate through the Holiday Inn to tell all the attorneys who remain in the litigation, you will get a rate for your room of about $125 a night. And that is considerably less than anywhere else. And so you're going to have probably, I would estimate, support staff, attorneys, witnesses will also be there. You're going to have rooms probably of 35, 40 rooms being sold out. And you're also going to have that ancillary services of people are coming from Cheyenne and Denver, litigants in these cases. I doubt very much they're going to want to go home on a weekend. So chances are they'll stay. Their families will be there as well. I think that all translates into kind of an ancillary effect, but a beneficial one. You're going to have a business that will generate sales tax revenue. You're going to have businesses downtown where they'll walk from the Holiday Inn to eat, perhaps go to shops, a museum, who knows. But, and on top of it too, this case involves largely local tradespeople and businesses. If we have to go to Green River, Wyoming, those people are going to have to be away from their businesses, from their jobs, from their work. That's going to be really an incalculable financial strain on them, because this case is set for 4.5 to 5 weeks. And I would anticipate it'll go that long. So our request for your consideration, and I'm sorry it's short notice, we did the best we could. Deb, would you mind, could you please pass out that current? Okay. If you wouldn't mind, just take a quick look at those. You can see If we went 19 days per total jury trial or 26 days, we've given you alternatives. The 19-day jury trial, 3-week trial with boardroom, 10,410. 4-week would be 14,080. That does not include, as Deb has indicated, taxes or miscellaneous. But I think those would be reasonable as well. But at this time, I have a status conference at 9 o'clock with all the remaining attorneys with regard to the Gunworks litigation. I'm going to summarize the rulings that still have to be made on the dispositive motions. I'm also going to tell them that obviously, I don't know what that ultimate decision will be, but it will be forthcoming this week or next. But it does appear that there will be some parties still remaining in the litigation that will not settle or otherwise be dismissed from the case. And so with that said, I'm then going to approach them that these are my alternatives. I've checked with the commissioners. I'm seeking their direction and guidance on this as far as finances. But if we do try it, chances are it would make sense to have it here as opposed to Green River. So that's my position, and appreciate your time very much. And thanks for getting us in on short notice.
Madam Chair, just a question about security during lawyer palooza that you have going on. Have you discussed that at all at the Holiday Inn?
You know, I have discussed that with them, and I think we're going to have probably 3 or 4 bailiffs as opposed to 2. And the reason for that is it's a very large jury pool. It's a long trial. Bailiffs are just like jurors. They may have family emergencies and they may not be able to ride the whole case out. The bailiffs are very good with security. They're not licensed to carry firearms and they can't use deadly force. But they do an excellent job in monitoring the courtroom, making sure they come and go. It is a public place, just like the courtroom, but it's a little more of a public place, Commissioner Mangold, because it is a hotel and a restaurant. But I don't anticipate problems. I'm going to check with Sheriff Stewart. He's been incredibly cooperative and helpful with us. And I think if we had any issue, he might have a deputy down there at various times if we needed it. But I just, you know, courtroom security continues to be a strange and interesting question. I just wish it wasn't. I truly wish it wasn't. But, you know, in court, we see it continuously. People wander in there. They've got knives on them. A couple of them have guns. I mean, it's just, you know, I deal with it. We keep it calm, but you know, we don't have any measure of knowing who goes in there and who goes out of there and what they're carrying or what they're not. And that is just the reality. But thank God we haven't had any problems. I don't think we will have any problems. And I keep my fingers crossed. And Deb's very vigilant in that. So is Teresa. They let me know, you know, this is a difficult client. You might want to ask some questions here. I will say this. I have asked them many times, do you have any weapons with you? Yes, I do. Well, could you please put them on the table? They put them on the table. I gather them up. We have the hearing, and then at the end of it, I give them their weapons back. So people are always respectful and decent, and we're fortunate in that regard in Park County. But I think that the security issue can be resolved with Darrell Stewart and with the bailiffs as well. Mike Neville is our head bailiff. He does a great job. He's had, I don't know, 7 or 8 jury trials in the last several years for us, and he's dealt with every conceivable situation. And so I trust him completely, and he has a good relationship with law enforcement.
Thank you. Other questions from the commissioners at this time? Okay, before us, we have a request that would basically supplement the district court budget. If in fact we have to at the end of the budget year, it is something that we know if we get to the bottom line and it's over, this would be a reason it's over. And we would have the ability to do a budget amendment at the end of the year to cover these costs. So we do not know what the final number is due to a few of the outstanding things and not knowing for sure the length of the trial. So we would be, in my understanding, we would be approving the county supporting paying the costs for this trial to be held at the Holiday Inn if necessary to the cost that the district court provides us.
And I can promise all of you, I will do everything I can to monitor and make sure that the costs are reviewed daily so that if we have any deviations, and I can't imagine we would, I'll let you know as soon as possible.
Is there a motion from the commission?
Madam Chair, just for clarification purposes, and you might have stated this and I might have missed it. I have 2 questions. The first one is the district court budget covering a portion of this that we don't see on this form, or is this the entirety of what the amount is?
The entire amount.
The entire amount. Okay, and then my second question was, there's two separate, there's the 19 days and the 26 days, but you thought it was going to go 4 to 5 weeks. So is this estimate, so I guess the question would be for the motion, which time frame?
Just say the length of the trial.
Okay,
I mean, that, I don't think we can explain the number of days at this point, so the
Right.
length of the trial would be the only way I could think of that we could cover this.
Madam Chair, I believe we won't know until end of June where we're actually at financially, and at which time it's no different than any other department. Well, if it runs over in any one of their categories, then we do a budget amendment to compensate for that. There may be possibility that he'll save a little on ink. I don't know.
I hope.
But, so I don't even know that we need a motion, but if we do, I mean, it would just be to approve to go to a supplemental area
If
for the
necessary.
trial. And we'll do the budget amendment when it's
in
time,
June.
If necessary.
if necessary, which most likely will be, but Madam Chair, Mike, I'm not a lawyer, obviously, right? But is there any
Thankfully,
way that
You
the
know.
cost of a trial can be compensated if the wrong party loses in this situation? Like being a civil, I don't,
You know, we really don't have, we have the American system versus the English system in England that, yes, you can be assessed almost all taxable court cost and fees, but under Wyoming law and the United States, it basically says if it's not in contract, you're not entitled to those attorney's fees, or if it's not provided by statute, you're not entitled to the attorney's fees. But no, the cost of actually impaneling a jury, all of the expense necessary, Deb's expenses, or administering as the clerk of the district court, those are not compensable. You cannot recover those regardless of who prevailed. But it's a great question. And it has been argued many times. And I think if it was in place, it might limit litigation. But instead, it kind of enhances it sometimes. But
I mean, Madam Chair, I certainly understand I think it was a great presentation to understand the size of this trial and, the capacity issue in our courtroom. Sweetwater County is certainly, I think, cost-wise, it's going to end up being the same as staying in Park County. So
At least.
I would be comfortable motioning to approve the budget. I guess the motion would be to approve the budget for the duration of the trial. So I'm not sure how to word the motion to,
I
The
guess,
trial, it's going to vary,
right.
between now and the trial, and that's what I suggested to judge, is give them a deadline. That if you don't settle between now and
It could be
this
more.
date, that, you're gonna go.
Yeah.
So you may lose some people, and that would help and speed up the trial.
I just think that we agreed to the trial being moved to an off-site
Temporary
location and review a budget amendment if necessary at the end of the year.
that'll be my motion. I make a motion that we approve the trial being moved to an off-site location. And that we would review a budget amendment if necessary ahead of the budget planning.
second,
Been moved and seconded. Is there any further discussion on the motion? Further discussion on the motion to approve the off-site location and a budget amendment if necessary? Hearing none, all those in favor?
aye.
Aye.
Anyone opposed? Same sign. Motion passes. Okay,
Madam Chair, I just want to say to all of you, thank you very much. We really do appreciate your time. And, for better or worse, I'm set to retire by state statute in 2 years. And I think it would be comforting whoever takes the job, he or she in the future, to know that, when we do have, I think we will have these issues. We see more and more of these cases as things evolve in Park County. And as I say, it's a great courtroom, but it does have limitations, particularly when you come to numbers. And I want to tell Commissioner Mangold, sometimes he scrutinizes me on my budget with regard to my office furniture. And I have taken some brackets, some new brackets I did get for $1.98 at True Value, and I put those on the chair. I think the chairs are good for another 3 years. Okay, but the table, I had to get rid of it.
Oh,
okay? But I do have kind of a picnic table in there that I got from my son who made it. So it's, and that will stay when I leave. So, but thank you all.
Maybe you can sell those ashtrays off.
Well, but those ashtrays, there's a real market for them. I just haven't found a buyer yet. That's the problem. Hey, thank you so much, all of you. We really appreciate your time. Thank you.
Thank you.
Thank you.
Okay, the next thing on our agenda this morning is the consent agenda. Approval of minutes of January 7th and January 14th, 2025. Approve payroll, approve vouchers, approve monthly earnings and collection statements from the clerk, clerk of district court, and the sheriff. Approve and sign FY 2024 Q1 TANF and CPI reports and vouchers, and approve and sign the lease renewal for Collection Professionals, Inc.
Madam Chair, I move to approve the consent agenda as presented.
Second.
Been moved and seconded to approve the consent agenda as listed. Is there any further discussion on the motion?
Madam Chair, I just wanted to make sure some of the suggested changes were in my packet earlier, the suggested changes that I had emailed on meeting minutes from 114.
Mhm.
They hadn't been updated in the packet, so I just wanted to make sure in this one. They
He
were,
Forwarded it to you in email, correct?
yes.
That's the
But then when
last
I looked at the packet, it wasn't.
Okay.
Yeah, so that will be the one we'll use
Okay.
to go to print. And I'll try to get better at forwarding them if we make major changes.
Okay.
Okay.
Yeah, sorry about that.
Any further discussion on the motion?
No, I was just gonna mention they're on page minutes if you want to look.
They are, but there was one sentence that she had asked to be added.
And it
that
hadn't-
isn't-
it
It
didn't
hadn't
get-
been on that copy, is her point.
Oh,
So,
okay.
Hold on.
correct.
Mhm.
I
So
did see it.
So they will be changed.
That's what Colleen's indicating.
And that was on the 14th, correct?
correct.
So do we need to amend or change my motion as
The corrected set of minutes.
corrected? That is
that
the
a-
first item of the consent.
that a
Approved
friendly
minutes
amendment?
as corrected.
You could do that.
You got that, Colleen?
Send them to you if you want to look at them.
I'm trying to find it.
Except probably that might be the 7th. She just sent it.
Here it is.
Then I can be sure what spot you're talking about, but I believe he did what you asked.
He did. I saw the correction. So one was just that the motion passed unanimously.
I just sent you.
Mhm.
At the bottom of,
The assessor discussion.
okay.
Okay, so as the motion stands, was that a friendly amendment that Kelly, you'll accept it as the
Yes.
minutes corrected? Okay.
Right.
Okay, so the motion is to approve the consent agenda with the word corrected on the January 14th minutes. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. Okay, we've got a couple minutes and then we have a review and approval of the Planning and Zoning Commission bylaws. And those are loaded in your SharePoint if you want to take a quick look through those while we have a couple minutes before. Ms. Hill will be here.
Madam Chair, do you know what page, looking at the document
Yeah, I
that,
think it's page, yeah,
9.
I was gonna say 7 or 9. I can't remember which one it was, but yeah, page 9. Under 9B,
9,
page 9, 9B.
cybersecurity awareness?
Yeah, if you want to read through that section, since that is fairly new.
One of those word games. You have a minute for.
Yes, go ahead. I don't know. We've been trying to reach him and he's not answering.
He's not answering.
Uh-uh.
It was home phone.
Yeah, I'll try it.
Something like that.
I know,
So it's okay. Because he wanted to shine.
not till after the meeting today.
Let's try this. You want me to call out the his emergency contact information?
Yeah, I don't have her.
Hey, is, Bobby,
These other two are the signatures. So it is.
Yeah, Pauline will take care of those.
it's the end of the talk.
You what?
Some Scott.
No, we're trying to get another contact number. right now. Where's number?
Well, I was gonna, because if Bobby's not there, I have to go to the system. I can find it, so I'll be, but go ahead and start, because I have it recording,
Okay, thank you.
so if you need to start.
Keep working. Oh, we still got a couple minutes.
What time is it?
9:05. Making me nervous. Me too. It's a long drive. Please. Oh, jeez.
This
Ugh.
one.
You want to put the date on there? There's a line, line for the date. Right there.
Here's,
The line for the date.
want me to fill it in? It'll be dashes instead of slashes.
I don't care. As long as
What
the
is it,
date's
21?
21, yes.
We expecting any of the commission?
Nothing I'm aware of. Doesn't look like it. They know it's on there, I think. They worked on it last week.
What's that?
They worked on it last week to finalize it. I think we'll go ahead and get started. The next thing on our agenda is Joy Hill, Park County Planning and Zoning Director, review and approval of the Planning and Zoning Commission bylaws.
Madam Chair, thank you. So as you're aware, the current development standards and regulations house the technical bylaws of the Planning and Zoning Commission, sort of an unusual situation where a board's bylaws would be contained in our regulations. So one of the recommendations that came out of the reg amendments was to remove that language from the rules and have a standalone bylaw that the commission could then amend as they see fit when they need to. Because at this time, they would need to actually hold 2 public hearings if they wanted to amend their bylaws and the regulations, which is just not customary. So what you have before you is a draft of Planning and Zoning Commission bylaws. These were approved by motion of the majority of the Planning and Zoning Commission last week. I know there's probably a couple questions about maybe certain sections, concerns about cybersecurity and electronic devices. So I'll leave it to you to share any comments or edits that you may wish to have. I will say that the county attorney has requested the opportunity to review and approve this document to form. And so if we could have, if you do choose to approve this document, I would ask for that condition. Further, we would like to request an effective date that matches the effective date of the updated regulations. That's the development standards and regulations at such time as they may be adopted.
Amendment one, round one or round two?
Round one. So the current regulation amendments at such time as they may be adopted, whatever the effective date of that document is, we would like that to match the effective date for this document,
Okay.
or the date that the county attorney has provided his approval as to form, whichever is later.
Okay.
And I can obviously write that condition to reflect that if you approve that condition. Madam Chair, I believe you had pointed out there was a typo on page 7.
Right.
Under little c. Instead of saying the identify of the party, it should say the identity of the party. So I'll note that for the board. And then I believe there was another one that I didn't write down.
It was a double paragraph. Let me see if I can find it. It's toward the end. Oh, boy. Let me see if I can find it. No, that's not it. Give me just a second. I know I'll. Just 2 particular numbers read almost, well, at least when I read them, they read almost identical. So I wanted to clarify what the meaning was. Okay, on page 5, at the top, C and D, if we could review those, if there's a difference there, I am not catching it.
No, I think you're correct. One says biannual and one says biennial. There's definitely a difference. I think the intent, Madam Chair, was to have letter C. Biennial versus biannual. I think we need clarification to make sure we all understand the difference.
Biennial means taking place every other year.
Okay, that would be the intent, as opposed to reviewing it twice a year.
Right.
So we probably could strike D, keep C, but change biannual to biennial. If that would be the wish of the
So
board.
I'm to understand, Madam Chair, we're gonna strike the entire D.
D, right. And change the word biannual, review of the land use plan to biennial, right?
Yes.
Okay. And that's on page 5.
Thank you for that catch, Madam Chair.
Mhm.
And then, of course, on page 9, if you would like to discuss the personal devices and the cybersecurity sections, which were the latest additions to this document by the commission.
I would just start by saying I understand the thought processes. I do think that the Planning and Zoning Commission is a little different than a lot of the other board members that we appoint throughout the county. Number one, they are a compensated board. Number two, the amount of work and review and information that they have to provide us on a minimum of a monthly basis is pretty significant. I'm not sure that we want to leave the part in here about county provided equipment at this time. We haven't really worked through that. We need to look at the costs involved a little bit deeper. We need to look at their insurance type of thing as far as county equipment. All of those kinds of questions come to mind. And we are in the middle of a budget year, which makes it a little difficult to look. I know there was a preliminary discussion about it could be as a little over $2,000 an employee if we did everything, or not employee, for commission member. So I think those are some things that we need to look at and determine if the county really wants to do that or not. It does not have to be in these bylaws for the county to do it. So I would suggest that we strike that in the bylaws right now and work through the process and get some questions answered that we have. And if we determine that we want to do that, we can work it through the budget session.
Madam Chair, you're suggesting striking all of 9?
No,
Just section.
just section 2.
Okay.
And I'm okay. I mean, I don't mind them having county email addresses, just because that does have the connection and the continuity. And I believe a couple of them already do. Not a problem. They have to follow the same rules on the county email use as all employees and elected officials do. So I don't have a problem with that. It's just when it talks about the equipment,
Yeah.
there's the rub.
Yeah, Madam Chair, I totally understand where you're going, and I think it's something that we need to discuss further going into budget as opposed to this time of year. However, I'm just gonna, as I read it, I see just it's worded recommend. Doesn't mean we have to at all. Unless I'm reading something different. To ensure security of property documentation of commission articles, we recommend using county issued email addresses and devices. So
But we
I'm-
haven't issued devices. That's kind of saying that we are issuing devices if they recommend that they use county devices, and we aren't going there yet. I understand the email.
No, yeah, and I don't want to go there yet without
Okay.
review of from.
Do we just remove the wording, the devices, leave the email?
Madam Chair, I have a
Okay.
recommendation. So I understand that this section is about electronic communications and cybersecurity. I would think you could rename little letter A. In fact, you wouldn't even need a little letter A potentially, or you could limit it to saying, like basically deleting the first sentence of little number 1 and just saying communication concerning county business, whether through county or personal devices and emails, may be subject to public records requests or subpoena, and just keep it simple. And then number 2, to ensure the security and proper documentation of commission activities, we recommend using county issued email addresses whenever possible, striking and devices, and keeping if personal devices or accounts are used, members should be aware that these communications can be considered public records. I think that achieves what you're trying to get to. It's not eliminating the allowance for devices of any type. It's just generalizing. So I think if we keep it to electronic communications and cybersecurity, change little letter A to electronic communications. change little letter I by deleting the first sentence, change little letter 2 by removing and devices, and then letter B would remain cybersecurity awareness.
Mhm.
I think that achieves what you're talking about.
I think so too.
Yeah, I think it's important that that the cybersecurity awareness
Oh,
is,
yeah.
is part of
Absolutely.
it,
Absolutely.
for sure.
Any other thoughts on Joy's recommended changes?
Yeah, I like the changes. But there is does the chair have a email if somebody wants to email the chair? Do they have one now?
So
They reserved for that.
So Planning and Zoning Commission members are given the option to obtain a county email address if
Right.
they want. Not all commission members have chosen to do that. At this time, the chair does have a county issued address because that was his choice. But they don't have to do that. Any member who does get a county email address has to comply with the county's email security requirements, which is training and all of those things, as you're aware. So they're held to the same standard for the use of that account as we are as employees.
I'm just thinking that it would be nice on our website to direct people's question to the Planning and Zoning Board with one email address. To be
And-
sort of a
and
clearinghouse.
I actually just discussed this with the chair recently. So annually, when we have a board change, we check with our board members to see if their communication means have changed, like email, phone, things like that. We had one member who didn't want their email address or phone number published. And so then bringing that forward to the chair is like, what is your intent as to how your appointed commission or board members should be communicated with by the public? So is it the intent of the board that everything would go through the chair, or should the public have the ability to contact any member of a board? And I guess I'm still going to have to be seeking clarification for that then, because on our website, we put the names of the board members and which planning area they're from, but we rely on the county's board page to put the how you communicate with them part, because we don't want to have, discrepancies in that information. But it begs the question, is an email address satisfactory? Is a phone number satisfactory? And, or, how, or neither? Like, do they have that option? What is the board's intent?
Our administrative assistant and I have talked about this quite a bit this week in talking about all boards with the county and that board page that you're referring to. Because there's all types of things in there. There are email addresses, there are street addresses, which I believe we can delete. There is no need for anyone to know where any of our board members live. If the board member wants to give out that info, that's up to them. But some form of contact, whether they choose it to be a phone or an email address, I think we have to have one or the other, because they have gotten on a volunteer board to represent people in some form. So I do think we have to have some manner in which to get in touch with them. If we've offered the Planning and Zoning Commission the ability to have county email addresses, I think that's great. I think if I understand you right, Commissioner Mangold, you're talking about similar to our commissioner's
Right.
email that goes to all of us all the time. So it's not independent, but we do all see it. So if there was an email that was P&Z@Park County, something like that with the yo.gov, they would all see that. Again, then the reminder is where there can be issues with ex parte communications when you're all on the same email. You've got to be careful on that type of thing, but that's just a learning curve. But I do think that would help them and maybe help the public be able to get in touch with all of them. Just send their information to them, and how the chair handles that usually is up to the chair, depending on which commission or board you're talking about. But for the most part, that's my understanding.
So Madam Chair, if I think I heard it correctly, you're suggesting there be a single email point of contact that then the chair would disseminate,
And
or?
I think that would help at least slow down any ex parte communication too. If you have an email for these two, can you cooperate with me with the rest of the Planning and Zoning Commission? So I think if you just have one, if I'm looking for a question or a comment to the Planning and Zoning, if I can just hit Planning and Zoning, so it goes out to everybody who's on the planning and zoning, just hit that one email. It would make things a lot simpler and avoid any behind the scene things that may be going on or.
So Madam Chair, Commissioner Mango, you're suggesting adding this in addition to the option of having their own personal.
The individual ones. I don't see where, even though it's a planning area, the comment should be to the whole planning and zoning board, is what I'm saying, even if.
But my question, are you making this mandatory or are you saying it could
No,
be in
I'm
addition to?
Making a suggestion, and that could be for all of them.
So then it would be covered, and if an individual member did not wish to put their personal,
Right.
then they would still be covered by this. So I like that.
Yeah.
I would hope that they would be willing to be contacted individually as well. If they,
I don't think that's something that we have to change in the bylaws today, but I think
No.
it's a thought process if Director Hill wants to take that back to the P and Z Commission and give them those thought processes and see what they think.
Okay.
So,
Madam Chair, it does look like if you look at like the city of Cody Planning and Zoning and you look at Powell Planning and Zoning, kind of what Commissioner Mangold is talking about, there's one spot, you hit email the P and Z board.
Mhm.
So it's kind of looks like what municipalities are doing as well.
Yeah, and it may help protect their personal, phone number and email address that way, which I think would be certainly a
Right.
positive.
and we could
So-
do that on our board page. We can have who they are, but the
Mhm.
contact is planning
One
and zoning,
email.
yeah,
Mhm.
type thing.
And IT can create an address.
Oh, yeah.
I mean, that's
Oh, yeah.
easy, so.
Okay. Commissioner?
Madam Chair, though, we don't have to have this approved today, do we? I mean, there is not such a sensitive timeline, or is there that we could request that these draft changes be brought back to Planning and Zoning Commission as well as reviewed by our county attorney perform, and then we could put it back? Well, is there time by February 4th agenda?
So, Madam Chairman, the idea is that these bylaws be ready at the time that any regulation amendments take form, because once the regulation amendments are approved, whenever that may be, then they won't have bylaws because they will have been pulled from those original regulations. So we wanted these to, so long as they align
Okay.
with the effective date, it
As
shouldn't
long as we
matter.
get it done before the
Okay.
round one amendments are done.
Okay, round one amendments. It's possible, I don't know how probable, but it's possible that they could be voted on January 27th. But we've talked about the fact that they could be approved at that time, but not instituted for another 2 to 3 weeks after that due to the time frame of changing forms and processes in the planning and zoning and having them get ready for those new regs. So if that in fact is the case, then February 4th certainly falls within that time frame. If these were to come back to us after the changes have been made.
Is it the intent, Madam Chair, for these changes to go back to the Planning and Zoning Commission though, because they don't meet again until mid-February?
Discussion of the board.
Commissioner Teal,
My question is, even though they may be voted on as possible as 27, not without a special meeting, because they're not approved or adopted until we decide, not the commission.
That is a special meeting on the 27th.
Is right now scheduled?
Yeah, it's public hearing and meeting, yes, next Monday.
And Madam Chair, I
You're right.
guess I can kind of speak for the commission and that we worked on these bylaws together. I don't think there's going to be any harm in what you're proposing because you're just removing some language. I don't know that there's going to be any heartburn over that. You're still communicating the message that they're asking for, but you've just removed, I guess, language that you wouldn't be supportive of because there's not the option at this time, but open to whatever you recommend.
Okay,
Madam Chair, just
Commissioner?
one more quick question.
Okay.
If our county attorney comes back and makes some visual changes before, what do we have an option to change it at that time?
yes.
There could be more
Yeah.
edits.
There could be. And again, you are the board that appoints the Planning and Zoning Commission. So ultimately you are the ones who approve their bylaws in that regard. So
And there's nothing to say that 6 months from now, if something comes up and something needs to be changed, we have the
Yeah.
ability to do that.
Yeah.
And Madam Chair, just as a point of clarification, removing, the county providing devices, just removing that language doesn't prohibit us
No.
from providing them. So as long as, I think if your concern is maybe they would, Commissioner Teal, that they would have a issue with some of our changes. I think if Joy goes back and communicates to them, it doesn't prohibit us from providing it or to even discussing it, right, down the road. It's just removing it as a requirement, or a suggestion, I guess.
We're not sure we're going there yet.
Yeah. Correct? Is that,
Yeah, and it's not, Madam Chair, it's not even so much the commission as our county attorney have not looked at this. I mean, and if he wants us to change anything,
Mhm.
basically, we're giving him the permission to approve it.
He can make
because it doesn't,
suggestions to us.
it doesn't come back to
Exactly.
us.
Form.
But if we approve it today,
Yeah, but
But
you
we
could,
are-
you-
That's true.
I'm sorry, Madam Chair, we did mention at the beginning, though, that you can approve it with the condition of the county attorney's approval as to form.
as to form.
So, he could approve it as to
Madam
form with
Chair,
recommended
With our
changes.
county attorney here,
Let's
as
let
to
him weigh
form
in.
means you can't change anything. You just agree it looks okay.
Clarification, if I have changes, I can't approve, so that would have to come back to you.
Right.
That's my point. If it's got to come back after you, or unless you have no changes,
Right.
If I have no changes, it would be approved.
And-
If I have changes, it would come back to you.
And that's kind of the motion that approved contingent on the county attorney's approval to form. If he has thoughts, then it comes back.
That's our safety net.
I understand what I think I understand what you're saying, Commissioner Teal, because you're concerned if there's changes, then it has to come back to us.
Right.
And then we have to meet again to,
and we already know there's gonna be changes, so why don't we just make the changes? Then I know it puts it out, but
Oh, I see
we
what you're
could,
saying.
effective date could be the answer. I mean, we still have the hearing, but
So, Mr. Skorick, is there a possibility that your office can review this before February 4th?
We're talking.
The bylaws for the Planning and Zoning Commission?
That gives us plenty of time.
Okay, so if we said, let's put this back on the agenda on February 4th to look at a final copy has been described by Joy with the corrections made, and we will have input from the county attorney's office as to form or concerns. We can vote on it at that time and still hit possibly a time frame that we're looking at. Does that work?
Yeah.
Okay,
Absolutely.
thank
We
you.
need a motion.
but do we need a motion for the proposed changes?
to table.
I think you
No.
just
Or-
tabled,
Just
because you're waiting for the county attorney's potential changes, is how I heard it.
But do we need to make a motion to put our edits in?
Nope, we're
They'll
gonna
be
ask her
part
to
of
make
it.
the changes we've discussed and bring them back in final form.
Okay.
We don't need a motion to table.
Thank you.
Madam Chair, I move we go into executive session.
Hey, in that executive session, because they just removed the back door of our room, is gonna have to be across the hall.
Okay, second.
All those in favor?
all right.
Did we get a hold of Scott Stewart's?
Paper Ferry was here.
Paper.
Oh,
We're gonna come up with a nickname sooner or later, so we don't have two Kellys. We just don't know what it's gonna be. Paper Fairy, okay.
There's acting up, it just is spinning, spinning, spinning. and won't be Here in the commissioner's. And we're ready to start again. Yeah. Control what delete, let me just push the button and shut it off. All right, come on up. You can come right up. I could probably do manually. I'll have the recording. So.
We need to wait on that too.
No.
Madam
She's
Chair, I
gonna-
move.
She's got it right, though.
Give me 1 second.
Yeah, there's an email.
Okay.
Madam Chair, I move we come out of executive session.
We're out.
Where would you?
We don't do a motion.
You don't have to
Executive
move to
session.
come out. Madam Chair, I move to approve the proposal discussed in executive session.
Second.
Been moved and seconded to adopt the proposal discussed in executive session. Any further discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. With that, we're a couple minutes late on a public hearing. So the next thing is a public hearing, review of Dead Indian Tower SUP number 270 with Jenny Kramer and Erica from our Planning and Zoning Office.
Thank you, Madam Chair. Mastech Communications Group submitted a special use permit application to review, and they request to review and approve a special use permit to expand a pre-existing unpermitted 89-foot tall cell tower site. They are just adding on and putting in a generator and a diesel fuel tank on a 4-foot by 10-foot concrete pad with an 8-foot by 16-foot fenced compound, as well as a utility H-frame, alarms, and other necessary supporting equipment. The communication tower is classified as a major utility use. It is located on Forest Service land, which is unzoned by the county. Private development activities on federal land are subject to county regulations, and these activities are to be reviewed according to the zoning district of the majority of adjoining properties. The majority of adjoining properties nearest the site are in GR 35 zoning district, and a major utility use is allowed in that zoning district with an approved SUP. The tower site is approximately 21 miles northwest of Cody on the east side of Highway 296. Neighboring lands, nearest neighboring lands to the site are, it is nearest to the site are adjoining the site are Forest Service exempt lands. The nearest private owned lands are approximately 3 miles away from the site and are ag and residential. The tower site is in a relatively flat area. The access road from State Highway 296 climbs steeply to the site. The existing tower site consists of an 89-foot tower equipment and a 15 by 21-foot equipment shelter. Notice requirements have been met. Relevant agencies were notified and responded as follows. DEQ provided agency contacts and information for permitting associated with the various construction activities. Game and Fish reported the proposed project is located entirely within crucial deer and elk winter range. The department recommends avoidance of human activity in designated deer and elk crucial winter range from November 15th to April 30th. Park County Fire District 2 provided a list of equipment that would typically respond to an emergency at the site. The Department of Fire Prevention and Electrical Safety will not require plan review or a wiring permit, as cell towers are considered a utility use and are exempt from their review. YDOT confirmed they have no concern with the project. The treasurer confirmed the lands are exempt from property taxes. Park County Weed and Pest will not require a long-term noxious weed management plan because the site is covered by a weed management plan as part of the Forest Service permit. The Forest Service confirmed they're working with the applicant to permit the expansion, and they also confirmed that the access road is part of their review. Park County Public Works reported that access to the site is from Highway 296 and YDOT has jurisdiction. The project will not have any impact on the county road system. An address for this facility is not required, but can be obtained through their department if requested. And they recommend the access road to the facility be suitable to facilitate the construction and continued maintenance of the facility. A comprehensive evaluation of the structure itself was not conducted by Public Works and is beyond the scope of this review. And since substantial disturbance of the area is not proposed, a stormwater drainage plan is not required. Rocky Mountain Power has not provided comment. No public comments have been received. Planning and Zoning Commission reviewed the special use permit application on October 16th and recommended approval with conditions. The proposed fuel tank will store 190 gallons of diesel and will be located on a concrete pad shown on the site plans. And the applicant was told by DEQ that since the generator is above ground and no fuel will be sold to the public, no permitting is required for the diesel storage tank. The applicant provided a statement of how compatibility will be achieved. They stated the proposed backup generator is a necessary component of the existing facility to ensure uninterrupted telecommunication service in times of emergency. The generator is intended to be run during emergency situations only when power is interrupted and will not create an adverse impact. And the proposed backup generator and fence compound surrounding the generator will have no impact on water, sewer, and wastewater or soil. The proposed facility will not be within 20 feet of a county road right of way. No covenants are known to exist on the property. However, the applicant must comply with the terms of the Forest Service lease agreement and their rules. No additional lighting is proposed. The applicant requests the board's approval to proceed without a soils report since the proposed disturbance and scope of construction is minimal. Designated parking is not needed for the use. However, there is adequate space for parking outside of the compound. If a chemical toilet is used during construction, it is required to be properly anchored and serviced. While in place, the applicant has stated the tower is currently connected to power service with Rocky Mountain Power. No new signage is proposed. Any solid waste generated will need to be properly stored in bear-proof waste receptacles and disposed of at the county landfill. No specific criteria are identified for the use. It is not located in an overlay district and site plan review is not required. Planning and zoning staff recommends approval of Dead Indian Hill Tower SUP-270 with the following conditions of approval. Number one, approval is granted on the applicant's proposal to expand a pre-existing unpermitted 89-foot tall cell tower site to include the addition of a generator and a diesel fuel tank on a 4x10 concrete pad with an 8x16 fence compound, as well as the utility H-frame alarms and other necessary supporting equipment. Number two, any modifications to the use, including but not limited to further expansion, placement of improvements, or increased intensity of the use will require an amendment to this SUP or a new SUP pursuant to the regulations in place at the time of the proposed change. Number three, the applicant shall not conduct construction activities at the site from November 15th to April 30th of each year, which is consistent with Game and Fish recommendations regarding human activity and crucial big game winter range. Number four, Park County noise, lighting, and other nuisance regulations shall apply. Number five, if a chemical toilet is used during tower and site construction, it shall be adequately anchored and serviced while in place. Number six, if signage is proposed at the county road, the applicant shall obtain the necessary permits from Planning and Zoning Department prior to sign placement. Number seven, any solid waste generated at the site shall be properly stored in bear-proof waste receptacles and disposed of by a private company or other means to the county landfill. Number eight, the applicant shall comply with the terms of the U.S. Forest Service lease agreement and their rules. And number nine, the applicant shall otherwise comply with standards in the Park County Development Standards and Regulations.
Thank you.
Thank
Any
you.
questions at this time from the commissioners? Yes.
Madam Chair, Jennifer, I'm not sure where to go with this, other than the recommendations are just seem like they get longer and longer. I mean, number one, can you explain how that is even a condition?
Number one?
Yeah.
Oh, well, we have been trying to state what is being approved so that it's clear if they decide to expand or do something, it's
Is that
clear
not
what
what the
was
SUP
approved.
is for requesting though? I mean, I guess I'm
It
not
is.
following why you
It's-
need number one. That is the SUP.
Yeah.
So
And
it's not
that's-
really a condition.
Right, yeah, and I mean, it's up to you. It's just made it a little clearer when people come back to us. Because sometimes, you know, if it's in the findings, it should be you know, we should be able to rely on that, but it does seem like it's been questioned in the past. So we just thought to make it abundantly clear, we've been putting that in, but we can change that at your request.
That just seems to me like a lot of extra rules. And then if move on down to number 4, I mean, a lot of those are already, they're repeated.
It's part of
You
number
don't need
9.
4, you don't need 5, you don't need 6. Those are all part of 9. Number 7, I mean, they have to, number 8 takes care of almost all of those. And 9, if it doesn't, 9 takes care of any additional. The one about having to come off of, getting a permit to come off of a county road. We all know there's no county road there.
Oh, at the county road. Good point. Yeah.
I'm just asking to simplify these
I'm-
conditions.
Access road.
I'm not disagreeing with you
Okay.
on that. So yeah, if you direct us to get rid of those, that's fine with us.
If we don't get rid of number 6, we may change the word county to access road.
Right.
Just clarification
Mhm.
that it's not county.
Carry over.
Any other questions for
Thank you.
staff at this time? Hearing none, this is a public hearing. Is there anyone that would like to speak to this request for this SUP? Again, is there anyone that would like to speak from the public regarding the review of the Dead Indian Tower SUP?
Madam Chair, I move to close public hearing.
Second.
Been moved and seconded to close the public hearing. Any discussion on the motion? Hearing none, all those in favor?
Aye.
Anyone opposed? Okay, motion passes. Public hearing is closed. It's the pleasure of the board.
Madam Chair, I move to approve special use permit. You want the number? I gotta get back to it.
270.
Permit 270, Dead Indian Hill Tower, special use permit with staff recommendation and conditions excluding 1, 4, 5, and 6.
Second.
A motion and a second to approve SUP number 270, Dead Indian Tower, with the removal of staff recommendations 1, 4, 5, and 6. Any further discussion on the motion?
Madam Chair, does the applicant get a copy of the Park County Development Standards and Regulations? Like they have a full copy of that document, so they know that these are all in there?
They have access to it.
Online.
Mm-hmm.
So my question would be, is the point of having some of this information in there for the applicant to reference like as a legal document? And number 2, for any of the surrounding properties to also be able to reference that these things were done? I mean, my only concern is I don't know that the general public is, you know, if I'm a neighboring property and I have some kind of question, I may not know that I need to go to the Park County Development Standards and Regulations to find the ones that we're striking, you know, 4, 5, 6, whatever they were. Is it more there with the intent not to be
Of
more?
those that really apply. I mean, they're just, I guess it's kind of noting regulations that could apply to this use that we just, as kind of
Specifically.
a reminder. Yeah.
I mean, I
Yes.
understand what you're
Yeah,
saying. It's
yeah.
redundant.
Yeah, it could be in some instances, especially if we had received public comment of a specific concern. With this particular property especially, it's totally surrounded by
Right.
Forest Service. You have none of that. There is, you know, aside from noise and lighting and other nuisance regulation, I mean, there's 330 pages in our current amendment to the regulations. I mean, where do you end? I mean, unless there is a specific concern, that's the only thing I don't have a problem with addressing specific concerns. if they are brought up by a neighbor or the public in a SUP, but just to randomly throw these in just to me, it just confuses it, the SUP.
Yeah, I mean, however, I think it also could be argued that this company is not from here. They, you know, if they're actually, I don't know who's gonna actually be doing the work, but it, you know, it might serve as a reminder that some of those things do apply that may not be on the radar. Although, like you said, it may be with the Forest Service lease too. I don't know, but
I guess that's my
as
only thought. I
consideration.
understand why they don't have to be in there 99% of the time, and especially on one that's been reviewed and we've had a lot of public input. I think
Mhm.
sometimes it is a reminder. Does it hurt anything to have them in there? Except the list. I mean, I don't know.
No, it doesn't hurt anything. We could save a lot of trees by not printing all this damn paper too. I mean,
Probably true.
the condition 9 is there. You must,
Right.
you
No, I
you
agree.
have to abide by the standards and regulations.
I agree.
Yeah.
And that's true. I mean, and
Enough
it is,
said.
the
Mhm.
document is referenced in number 9, the document
Mhm.
that they would need to look at.
Mhm.
I just wondered if
Yeah.
it's, if the intent is to make sure that surrounding landowners, if they were to have an issue, they can pull this, they can see what they were required to do. I just don't know that the layperson
Right.
is aware that there's this regulations document out there.
Well, if they
To
pull
reference,
this
but-
and it only has, not only, if we remove those and number 9 remains, that layperson's gonna have to
They're
go
gonna see it.
look at the development standards, regulations and see where it does or doesn't fit. And then decide whether they have a complaint or not. So there is a tracking. There's not a
Yeah.
problem, even if with the 4 removed, there's a tracking.
And Commissioner Teal, you're not saying that this across the board, you don't want to see this across the board. For example, on this one, there was no public comment. But on another one that we may see, if there's substantial public comment, then you would want
Absolutely.
specifics. Okay,
Commissioner Simone, if we have any public comment or concern from the adjacent landowner or just a constituent out there of us on a special use permit, and the planning and zoning feels it prudent to emphasize a specific part of our development standards and regulations, I have no problem including that, but just to randomly put them in there just to complicate the document, in my opinion, is all it does. If
Yeah.
this wasn't an issue by the Game and Fish, that's why Game and Fish, I left it in there because they wrote a specific that they don't, that's not in our standards, it is our practice. But they had input. And those, in any of these agencies that have input in reference to our specific standards and regulations, yeah, I don't have a problem with those being reminded as a condition. But just to add them because we do, just saves a lot of, I mean, that's where we have enough stuff to read.
Sure.
Madam Chair, is there any legal requirement to standardize the recommendations? No. Okay.
Well, these are individual per SUP because different things come up on every one of them on these reviews.
Okay.
The only other question that I would have, and I don't even want to open this can of worms, but I'm gonna. Number 7, any solid waste generated at the site shall be properly stored, bear-proof waste receptacles and disposed of by a private company or other means to the county landfill.
Right.
What if they want to take it to Montana? I mean, do we
Right.
care? Can we just say a certified
approved
landfill or an approved
An
landfill?
approved landfill? Mhm.
I don't
Yeah,
mean to direct them to our landfill.
No, I agree.
if we can help it.
yeah.
So with that
And then
minor
approval,
correction
just
amendment,
to an approved disposal site.
whatever, yeah, whatever. I just didn't want to direct them to it,
I would,
only ours. Is
I
that
would
okay?
amend Scott.
Yes,
Okay, for that,
I'll second the amended motion.
Okay.
To make this idiot proof.
okay, so right now, we have a motion in front of us. And the motion is to approve SUP 270 for the Dead Indian Tower with the removal of the recommendations of 1, 4, 5, 6, and a clarification on number 7 regarding the landfill. Clear? Okay. Any further discussion on that motion? Hearing none. All those in favor?
Aye.
Anyone opposed? Motion passes. Okay,
Madam Chair, resolution 2025-05.
Oh, thank you, Colleen. And thank you,
Thank you.
commissioners. Thanks for the discussion and clarification. I think that,
Yeah.
that helps us.
I think we gain on these things all.
I just want to make your job difficult, Jennifer. I'm just trying to make your job just, I'm telling you, I'll simplify, just write one rule. Yeah.
Okay. Running a little bit behind, but the next thing on our agenda is a designation of official newspapers pursuant to Wyoming State Statute 18-3-517 for the year of 2025. As you know, we had this on our agenda a couple weeks ago at the beginning of the year and determined that we wanted to ask the two newspapers of general circulation in our area for a quote, because this does cost multi-thousands of dollars a year. And even in discussion with our, as Commissioner Teal brought up, our procurement policy, other things that are gonna cost us these multi-thousands a year, we take a look at how we handle them. So we thought we'd take a look at this. So we contacted the Cody Enterprise and the Powell Tribune, and we received information back from them. I guess the information is in SharePoint, and you were given a folder from the Powell Tribune. We have my understanding of the statute, and county clerk can correct me if I'm wrong. We are required to publish in one paper of general circulation in the county always for legals.
Correct, Madam Chair.
We have in the past, since I've been here, we've used both papers. When I first came on the commission, the newspapers came together and met with us and determined that they would do, if we would continue to use both papers for that year and the following year, they would each do 50%, which gave us basically the same expense we would have with one paper, but yet the public was receiving all of the information in both newspapers. It's still expensive, but it worked out pretty well. Since that time, the county clerk has noticed some inconsistencies in some of the billings that we've seen, and that maybe that 50% is not being adhered to as much anymore. And so we decided to take a new look at it. So you have before you information from the Powell Tribune and the Cody Enterprise, and we need to make that decision. I need your thoughts.
Madam Chair, look, what I have reviewed, I believe that we financially, the people would be better off going with the Powell Tribune as far as rates. They have at least been consistent with their promise prior to. This is a limited edition rate, if I understand, and I do see Toby back here in the audience. You know, it's good for 1 year, but we are required to renew it every year. And to be honest with you, I think this opens the opportunity for competitive bidding like it was meant to. We have had a great rate in the past and appreciate working the two papers working together. For whatever reason, that doesn't happen to seem to be the case any longer. So with that, I'm going to go out on a limb here and I'm going to make a motion to approve the Powell Tribune as our official designation of official newspaper.
For 1 year.
Pardon?
the
For 1 year at
2025.
the rate proposed by in letter from Powell Tribune as posted.
I'll second that with a question. Colleen, did the Cody Enterprise give you a reason while the rate changed during this past year?
What, when we met with them, I'll go ahead and answer. Colleen and I did go down and talk to them, because there was some serious differences in some of the costs. And I will clarify that this is for legals. This is for our minutes
Right,
and
yeah.
legal notices. It's not for ads or things that we choose to do otherwise. but the costs on the minutes were coming in considerably different. So when we met with the Cody Enterprise, we were told that, yes, they understood, the new owners understood the 50% thing, but what they understood is it was 50% of their own rate, whatever that rate was, not necessarily matching the Powell Tribune or anything like that. So their rates have increased, and so they were using the 50% of that rate theoretically is what she was telling us, but it is considerably more.
Then a question to Toby, I guess.
Yes,
Yeah.
you can. Come on up, Toby. And there's a microphone, and if you just identify yourself for the record, please.
Thanks, Madam Chairman and Commissioners. Toby Bonner from the Powell Tribune.
Yeah, the question I have is I know you came in jointly with the enterprise before with a special rate. How does this now change for the rate that we could receive if you're not part of the Cody Enterprise?
Well, for clarification, and for history, for as long as I've been at the Tribune, which is 20+ years, it's been 50% of our rate and 50% of their rate. So it hasn't been a matching rate. It is off of our open rate. And so, and as you see on ours, we have a volume discount for the more use or the more inches you run in the paper. So their rate is more expensive than ours, you know, in the outset. So that part is how that works. But yeah, it's been that way for 20+ years that we've shared that, just because we both, you know, had interest in getting the information out to the public, you know, in our respective communities. So.
And we definitely would qualify as a lower rate with all the ads that we run.
Oh, sure. Yeah, and I gave you an example there, you know, but that's just one issue during the month. You know, you run a couple times during the month, and you combine those, and you probably drop down to another level on the volume discount. And also, it's for minutes and delinquent taxes at the 50%. All other legal notices, kind of like the P&Z, for example, is billed at the actual rate.
Madam Chair, so Toby, if I understand your proposal, though, you will, for 1 year, you will continue to bill us at the same 50% rate.
No, it would be
No,
actually
it's-
at our regular rate. So what I
What
was
is,
showing you there is the 50% rate. So it would be, for example, in 2024, for minutes and delinquent taxes, we billed the county $17,165.92. That is at our 50% rate. If you were to pick us as the sole paper for 2025, we would bill you at double that. So at our rate, respective of the volume discount, but it would be at our actual open rate or legal rate that we charge the city of Powell, or like your P&Z meetings and things like that. So delinquent taxes and county minutes would be billed at our open rate based on the volume discount. So in other words, the 17,165.92 would be doubled to, you know, this year, if at our 100% rate, legal notices would have been 46,386.78 in 2024 instead of the 17,163. And as far as competitively bidding, it's kind of hard for us to do that. And we obviously offer the 50% rate, you know, to get that information out in both papers, but we really, our open rate and the volume discount for the number of inches run is kind of our offer. That's what we offer the city or any other, you know, legal notices for companies or, you know, accounting firms, anything like that. So that is our open rate. And so we're at, that's kind of what the state statute says, that we offer you our open rate or any volume discounts that we offer anybody.
Commissioners?
I just want to make sure I'm understanding correctly. So what we were doing before, the 50% off, is now going to change, and it will be an open rate, but a volume-based discount.
Yes.
Madam Chair, which would still save the county in the long run because of their 50% rate is much lower. You know what I'm saying? I mean, as opposed to prior to,
with
and
the
do
vote.
we have, I guess this is my question. We didn't receive anything back from Cody Enterprise that said that they would guarantee us this continued 50% if we use both papers like we received from the Tribune. Is that correct?
We did receive from Megan, it's in your
But
SharePoint.
that is,
The Cody Enterprise
I
will
read
maintain
theirs
your
as-
current rate for legals, which is half of the open column inch rate at 1680, making your rate 840 per column inch for legals. This will be no increase for this year. And then, I thought there was another page here. It should be just before that.
just before
Yeah,
that.
go backwards.
Oh, yes. Which is 16,
Madam
So-
Chair,
the regular rate.
may I make a comment? I know, like, I believe it was the 23-24 budget, something like that. For us to pay both papers was costing us roughly $70,000 to $100,000 a year. So even with the rate of $45,000 a year for the Powell Tribune, we're still going to be better off instead of paying both papers.
So
Um,
They came back with a 50, to continue the 50% rate as the sole paper.
Yeah.
That's crazy. And
Um,
their rate is a lot more higher than ours.
Yeah, I don't know if it
To start
was
with.
sold. Well, that's their quote. I mean, that's-
We
sole
would
paper.
continue at the 50% rate if we stayed 50%, sharing with the Cody Enterprise. But if we're the sole paper, can't undercut our other clients, by offering it at a 50% discount, because then the city of Powell could come back to us and say, well, we want a 50% discount. So we have to be apples to apples.
Madam Chair.
Mhm.
Toby, what is your circulation countywide?
3,250.
We probably don't know the Cody Enterprises.
It's
3,250, yes.
it's in the 4,000 range.
And is there a second, I know, and I think it's with the Cody Enterprise, and you can correct me if I'm wrong, but is there a second paper that goes out? Not, it's like in addition
Heart Mountain
to,
Wrestler.
yeah, is that included? Does that,
They put their public notices in.
I
there.
don't know.
I don't know if
think
it's
so.
or not.
Okay.
It's a free publication that basically they shove all their display
I don't
ads in.
think our
Okay.
people's end up in
Okay.
there. That I'm aware of. Colleen, you've never seen minutes in that?
We don't get it in Powell, so it doesn't only circulate it in Cody.
Okay. Of that 3,250? Or I'm assuming, and I could be wrong, that the majority of subscribers then are Powell residents?
Majority.
And
Cody's growing daily.
yeah. And so we don't know about how big like Cody and Matitsi.
I have those numbers, yeah. We believe we're at 500 now, Cody alone and Matitsi, a couple dozen.
Just want to make sure we're getting it out countywide.
Understood. Madam Chair, I just want to remind all the commissioners that our minutes are also on our county website. There's more than one way to view the minutes. And then also I hate to assume, but all our advertising, if we need, if there's a special use permit for a public hearing or something, and it's in the Cody area, those would go out in the those would go in the Cody Enterprise as not the Powell Tribune, and or vice versa, or if it's something halfway in between, we'll
Put it in
and
both.
that's at our discretion to put them in either or both.
So the report that we have from the Cody Enterprise is still talking about half of the open column inch rate which is 1680, making the rate 840. Toby, in looking at yours, and you have the open rate without any discounting on there is 1475. Legal rates 1106. Are you talking if we did both papers, it would be half of the 1106, or if we,
Hmm.
or?
Yeah.
Is that correct?
it would be half of the legal rate, not the open rate?
Well, it's the same, yeah. So it'd be half of that 1106 or whatever volume discount came down.
Oh, because this is the volume discount.
Yeah, and it shows on the color page on the other side. how we Do that.
Oh.
Like a 2-column by 29 inches is 58 inches, but we only bill you for 29. So we bill you for 1 column times 29.
Instead of both.
Yeah, so that's the 50%. And then it's based on how many inches then to qualify for each volume discount.
And I know our minutes are considerable, the tax notices are considerable too. They're fairly
Sure.
large.
So I think probably some of your discrepancies in size, where even this week in the Powell Tribune, there's 3/4 of a page for the minutes, and the same page in the Cody Enterprise this week is a full page. And it's not at the notice statutes, but for size and stuff. So I'm not sure how that happens, that they stretch it to a full page. So
That means we had that discussion.
We did.
it happened again today. So you can look at both pages if you like.
Well, Madam Chair, as further discussion, my motion still stands as.
We have a motion in front of us to use the Powell Tribune for 2025 at the rates proposed. That's been moved and seconded. Is there any more discussion on the motion?
I mean, to me, I agree with Commissioner Teal that you can go online and see the minutes. It's costing a substantial amount of money to do both, it sounds like. And we've had some inconsistencies. And then, and as far as the charge that we're getting from one paper, and then also all of our specific items like SUPs and stuff will be advertised in the appropriate area. So I'm comfortable with that motion.
Any further discussion? Hearing none, all those in favor?
Aye.
Anyone opposed? Motion passes. So for 2025, we will use the Powell Tribune at the rates that you quoted.
Thank you, Madam Chairman, Commissioners. Just for note, anytime it comes down to it, we're happy to go back to a 50%. It's important to us to carry the public notices.
Appreciate that.
Appreciate it. Thank you very much.
Thank you.
Move to adjourn.
So I have a question with it. Chair, on that then, so when I send out the January 1 and 14 minutes, would they just go to the Powell Tribune, or do they just, so do those need to go to both papers still, since the motion was just made today to choose the Powell Tribune? And then starting with these minutes, January 21st, that's when we will begin to use just the Powell Tribune. I just need a little clarification. Although the minutes were approved today, they weren't actual minutes until the approval today on 1 and 14, but how would you like me to proceed with these minutes?
The motion clearly says for 2025. So that would be my understanding that the minutes that were approved today would go to the Powell Tribune. Is that,
Yeah.
I just wanted to make sure.
thank you. Scott, does your motion still stand?
Second.
It's been moved and seconded to adjourn. We are adjourned.